Sir, remove your hat in the courtroom, please.
No, be here. I think circle 10:30. I can go get her.
Well, I just, so you're moving eliminating 6 from the Okay, so is there anything we need to do on record? We have the podium, we brought out the position of the motion. Is there anything else? And basically what I've done is approve them based on the first one, requiring so only one school, one TV, and one hallway. So they're going to, I've seen no cooling agreements, but there have been several requests. So we're away, basically by the rules of court. And the only additional request was not to film the victim, but only audio. I expect that there may be slips from time to time. If their name comes up, it will be stricken. If occasionally use the word victim instead of victim or Django, I'll do our best. So if there's nothing else to put on the record, what we will do first is have the complaint read, and then I'll go right into instructions, and then right into open statements.
Fine.
Yes, absolutely.
Okay. We're going to turn the microphones on, or are we working?
They should be on right now.
Yes.
So we have a new person at the council table. We're going to introduce the investigation.
Well, we'll get introduce him before we instruct us wherever he is.
And already by the mailer. But absolutely, we need all cell phones, PDAs, any electronic devices turned off, not just on Friday, because it does tend to interfere with microphones as well as the court reporter's electronic equipment. So other than the news, the journalists that have been approved for using laptops in the pursuit of their business, all others must have their equipment off. Have we accounted for the jurors, Mr. Bailey?
The last time I checked, we were missing 3. I'll go back out and check the front rows also. I'll go back out and check right now. It appears everyone's sure you're on.
Okay, if we have the jury ready to bring in, why don't we go ahead and
I don't know if it matters, but we don't have any from the,
oh, we lost Mr. Hunt. He's here just a moment.
I think they went to the restroom down.
We'll pause.
I see them out there moving this way.
Yeah, okay, so I've opened it up when I tried to connect. So it's us. If you'd like to set something up, you may. We'll wait a few more minutes. Mr. Hunt, I think the jury's are up there. Okay, is everyone ready for the jury to come in? All right, let's go ahead and bring the jury in.
Yes.
The jury's gonna be walking right past here, so just.
I can turn this on.
Okay, jurors for Department 4, we'll go ahead and get started. Come on in.
So alternate one would be right here. That would be alternate three. I'll move this here.
Okay, the record will reflect the jury has now joined us. Give a minute or two to get settled in. Thank you very much for being so timely. And I apologize for the inconvenience. We'll have to move the chair around during each and every break to accommodate the alternate. So, ladies and gentlemen of the jury, welcome back. So as promised, what we're going to do first is have a formal reading of the criminal complaint, followed by my reading of the preliminary instructions. And then we'll go right into opening statements of both parties. And it looks like you're all ready to proceed. You have your notepads. You don't have to take notice on the instructions particularly. At the end of the case, you will be given copies of the law, of the instructions that apply in the case, and you'll be able to take them into the jury room with you for further reference. So you take those if you like, but you really don't need to. Okay, if we can have the formal reading of the complaint.
Yes, sir. Superior Court of the State of California, County of Sonoma. The people of the State of California, plaintiff versus Efren Carrillo, defendant. Case number SCR 637400. Criminal complaint. Count 1, PC 647I misdemeanor, peaking. On or about July 13, 2013, in the County of Sonoma, State of California, the crime of peaking in violation of Section 647I of the Penal Code, a misdemeanor, was committed by Efren Carrillo, who on or about July 13, 2013, in the County of Sonoma, State of California, the crime of peaking in violation of Section 647I of the Penal Code, a misdemeanor, was committed by Efren Carrillo, who did unlawfully, while loitering, prowling, and wandering upon the private property of another, Jane Doe, did peek in the door and window of an inhabited building and structure located thereon without visible and lawful business with the owner and occupant thereof. Signed, Deputy Attorney General Cody Hunt, dated October 30th, 2013.
And to that charge, that single count, the defendant has pled not guilty, and that's why we're here for jury trial. I would just point out that I believe that Sergeant Terry Anderson has joined at the Attorney General's table as the investigating officer. So please bear with me. The trial will now proceed as follows. The people may present an opening statement. The defense is not required to present an opening statement, but if it chooses to do so, it may give it either after the people's opening statement or at the beginning of the defense case. The purpose of an opening statement is to give you an overview of what the attorneys expect the evidence will be. Next, the people will offer their evidence. Evidence usually includes witness testimony and exhibits. After the people present their evidence, the defense may also present evidence, but is not required to do so. Because he is presumed innocent, the defendant does not have to prove that he is not guilty. After you've heard all the evidence and before the attorneys give their final arguments, I will instruct you on the law that applies to the case. After you have heard the arguments and instructions, you will go to the jury room and deliberate. Our system of justice requires that trials be conducted in open court, with the parties presenting evidence and the judge deciding the law that applies to the case. It is unfair to the parties if you receive additional information from any other source, because that information may be unreliable or irrelevant, and the parties will not have had the opportunity to examine and respond to it. Your verdict must be based only on the evidence presented during trial in this court and the law as I provided to you. During the trial, do not talk about the case or about any of the people or any subject involved in the case with anyone. Not even your family, friends, spiritual advisors, or therapists. Do not share information about the case in writing, by email, by telephone, on the internet, or by any other means of communication. You must not talk about these things with other jurors either until you begin your deliberations. As jurors, you may discuss the case together only after all the evidence has been presented, the attorneys have completed their arguments, and I've instructed you on the law. After I tell you to begin your deliberations, you may discuss the case only in the jury room and only when all jurors are present. You must not allow anything that happens outside of the courtroom to affect your decision unless I tell you otherwise. During the trial, do not read, listen to, or watch any news report or commentary about the case from any source. Do not use the internet or a dictionary or any social media in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. If you have a cell phone or other electronic device, keep it turned off while you are in the courtroom and during your deliberations. An electronic device includes any data storage device. If someone needs to contact you in an emergency, the court can receive messages that it will deliver to you without delay. During the trial, do not speak to a defendant, witness, lawyer, or anyone associated with them. Do not listen to anyone who tries to talk to you about the case or about any of the people or subjects involved in it. If someone asks you about the case, tell him or her that you cannot discuss it. If that person keeps talking to you about the case, you must end the conversation. If you receive any information about this case from any source, outside of the trial, even unintentionally, do not share that information with any other juror. If you do receive such information, or if anyone tries to influence you or any juror, you must immediately tell them about it. Keep an open mind throughout the trial. Do not make up your mind about the case or any issue until after you've discussed the case with the other jurors during deliberations. Do not take anything I say or do during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. Do not let bias, sympathy, prejudice, or public opinion influence your decision. You must reach your verdict without any consideration of punishment. I want to emphasize that you may not use any form of research or communication, including electronic or wireless research or communication, to research, share, communicate, or allow someone else to communicate with you regarding any subject of the trial. If you violate this rule, you may be subject to jail time, a fine, or other punishment. When the trial has ended and you have been released as jurors, you may discuss the case with anyone. But under California law, you must wait at least 90 days before negotiating or agreeing to accept any payment for information about the case. Now, you have been given notebooks and you may take notes during the trial. Do not remove them from the courtroom. You may take your notes into the jury room during deliberations. I do not mean to discourage you from taking notes, but here are some points to consider if you do take notes. Number one, note-taking may tend to distract you. It may affect your ability to listen carefully to all the testimony and to watch the witnesses as they testify. And two, the notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. At the end of the trial, your notes will be collected and destroyed. I will now explain the presumption of innocence and the people's burden of proof. The defendant has pled not guilty to the charges. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people must prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to acquittal, and you must find him not guilty. You must decide what the facts are in this case. You must use only the evidence that is presented in the courtroom. Evidence is the sworn testimony of witnesses, exhibits admitted into evidence, and anything else I tell you to consider as evidence. The fact that the defendant was arrested, charged with a crime, or brought to trial is not evidence of guilt. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys will discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorneys' questions are significant only if they help you understand the witnesses' answers. Do not assume that something is true just because one of the attorneys asks a question that suggests it is true. During the trial, the attorneys may object to questions asked of the witness. I will rule on the objections according to the law. If I sustain an objection, the witness will not be permitted to answer, and you must ignore the question. If the witness does not answer, do not guess what the answer might have been or why I ruled as I did. If I order testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you see or hear when court is not in session. even if it is done or said by one of the parties or witnesses. The reporter is making a record of everything said during the trial. If you decide that it is necessary, you may ask that the court reporter's record be read to you. You must accept the court reporter's record as accurate. You alone must judge the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you do believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but told the truth about others, you may simply accept the part that you think is true and ignore the rest. Perfect timing, so I think my allergies are overcoming me. So thank you for your patience. Are the people ready to proceed with their opening statement?
Yes. I appreciate it, everyone.
You may.
A woman sleeps in her bed, alone, in her modest apartment, right here in Santa Rosa, a few miles from this very courthouse. But she doesn't sleep peacefully, because at 3:30 a.m. in the morning, she's awakened by a rustling of her blinds, the blinds to her bedroom window. And there's a man lurking behind those blinds. wakes up, gets out of bed, turns on the light, she takes a look through that window, and she bolts into her living room. Where, luckily, she has two friends sleeping over that night, sleeping on an air mattress in her living room. She calls the police to report there's somebody trying to get in her window. She wakes her friends, but the man that she saw standing out there in the entryway of her apartment patio has left. She waits, talks to her friends. Several minutes later, that man comes back. This time he knocks on her front door. She says, "Who is it?" She's hoping it's the police. What does she hear? She hears, "Hey, it's your neighbor." She says, "Hold on." She stalls because she's hoping the police will arrive. At this point, she's got a butcher knife in her hand that she got from her kitchen. The man at the door, still not wearing his shirt, still not wearing his pants. He leaves, but the police show up. They stop him right there at that apartment complex. Ladies and gentlemen, that man is the defendant, Efren Carrillo.
Your Honor, I'm objecting to this argument at the time at this point.
Okay, overruled. You may proceed.
The woman, we're going to refer to as Jane Doe. You're going to hear from her. She's going to tell you who she is. She's a nurse at Kaiser. She lives alone. She was living in this apartment on Brockers Street since April of 2013. The event we're talking about here happens July 13th, 2013. The defendant, Mr. Carrillo, lives in the apartment behind Ms. Doe's apartment. She'd only had 3 previous interactions with Mr. Carrillo up until that point. They didn't have each other's phone numbers. Mr. Carrillo, as you will hear, claims he didn't even know her name. Just knew her by sight. She had never invited him over. But in one of those previous interactions, you'll hear how he came over to her house uninvited and showed up in her backyard with a bottle of wine, knocked on her back screen door. She was surprised to see him there, and says, "Hello, I'm your neighbor, here's a bottle of wine," reaches through her back door, hugs her, and kisses her. Now, we're going to talk a lot about the layout of Ms. Doe's apartment. We're going to talk about this diagram here. We're going to talk about that time that Mr. Carrillo came to the sliding glass door in the back of her house, uninvited. We're going to talk about a time when Mr. Carrillo saw her with her garage door open. We're going to talk about a time Mr. Carrillo ran into her at Space 25. That's a club here in Napa. Those are really their only interactions. And then, after those 3 interactions, you're going to hear that Mr. Carrillo shows up at her house at 3:30 in the morning. You're going to hear Mr. Carrillo raise the screen on her bedroom window, rustles the blinds, wakes her up. I told you Ms. Doe saw that night what she's going to testify to. But you're also going to get to hear it from Mr. Carrillo's own words. Because he spoke to the police officers who showed up that night. There are 3 different recorded statements that Mr. Carrillo gives to the officers. You're going to hear from those officers. They're going to tell you they showed up that night based on Jane Doe's call. I'm going to tell you they encountered Mr. Carrillo away from the apartment. And that when they encountered him, he was in his socks, his boxer briefs, and nothing else. They're going to tell you they found 2 bottles of beer that he said he had been holding, and a cell phone. They're going to tell you they didn't find any pants, any shirt, any shoes,